Let's go on the record on cause number DC213950, Arm Energy Management versus Medallion Pipeline Company. Counsel, make your appearances.
Yes, Your Honor. Richard Howell for the plaintiff, Arm Energy Management. Also with me today is my partner, Amy Baird, and in-house counsel, General Counsel David Cook and Gabe Newley, and two witnesses, Michael Christopher, the Chief Financial Officer of the plaintiff, and Scott Wishoff, Senior Vice President.
Good afternoon, Your Honor. This is Tom Patterson with Sussman Godfrey. I have with me my colleague, Kevin Downs, and in-house General Counsel for Medallion, Brock Degeter.
Do you have any witnesses?
Mr. Lastman got called away to tend to an emergency. If he comes back and we can get him, we might, at this point, with the hour that we have, unlikely.
Okay. All righty. Let's get started.
Your Honor, at this time, we offer plaintiffs exhibits 1 through 29. It's my understanding that we have an email-based agreement with Mr. Patterson that our exhibits and theirs will be admitted.
Any objection?
No, Your Honor. And as he said, our exhibits will also be entered, and that's Medallion exhibits 1 through 22.
Any objection?
No, Your Honor.
Have you emailed the court reporter both of those?
Yes, Your Honor.
Tony, do you have those?
We've emailed them to Ms. Penson, Your Honor.
Okay.
I did see, but I don't think I saw both.
Okay, make sure, Tony, go ahead and put in the chat your email address so that they can email you. Under the emergency order, it's supposed to go to Rhonda and to the court reporter. All right, so just make sure you have someone with your staff. Go ahead and email her the exhibits. All right, plaintiffs, you may proceed.
Your Honor, plaintiff calls plaintiff Arm Energy Management's Chief Financial Officer, Michael Christopher.
Okay, Mr. Christopher, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
You may proceed.
Mr. Christopher, what's your role with Arm Energy Management?
I'm the Chief Financial Officer.
And describe your role briefly with respect to financing and banking relationships.
I manage all capital formation and capital markets relationships related to banking and investment banking.
And is Arm Energy Management a publicly traded company, or is it backed by venture capital?
It is neither.
Are you aware of the financial commitments that are in place in connection with the Medallion terminal and transportation agreements?
Yes, there's approximately $14 million in cash as a prepayment deposit and approximately $19 million in letters of credit.
Who holds the $14 million of cash and prepayment deposits?
Medallion.
And who holds the $19 million in letters of credit?
Medallion.
And what bank has issued those letters of credit?
Iberia First Horizon.
And sitting here today, has Arm Energy or Glencore Limited, which was an assignee under the contract, paid all financial amounts that were due to Medallion under the terminal and transportation agreements?
Yes.
And could you describe for the court approximately how much is paid under those agreements each month?
It's approximately $1.2 million each month.
And has Arm already provided Glencore with a full March payment, or is that outstanding?
Yes, we have provided that.
Through the current term of the contract, how much has been paid by Arm and Glencore to Medallion?
Excluding the prepayment deposit, approximately $1.2 million a month since June of 2020 for about $13 million.
Okay, and you mentioned the prepayment deposit a couple of times. What was the purpose of that prepayment deposit?
It was additional credit support for the payments and obligations under the Medallion 2 agreements.
Okay, and when you say additional credit support, why does Medallion hold $14 million of ARM's cash in its bank accounts?
To protect itself for payments due under the agreement. So charges due under the agreement.
All right. You mentioned that the company is not private equity backed. It's not publicly traded. Could you describe for the court whether the financial commitments under the Medallion agreements are relatively large or small or normal or disproportionate compared to the other financial commitments that ARM enters into?
For ARM, these are fairly substantial.
And what do you mean when you say fairly substantial?
These are large and these are disproportionate compared to other long-term commitments of ARM.
Okay. Based on your understanding of the agreements and your experience as a financial executive in the industry, what is your understanding of what's supposed to happen to the letters of credit and the prepayment deposits if ARM terminates the agreements based on Medallion's breach?
If ARM terminates those agreements, those deposits and the letters of credit are meant to be returned.
Okay. Have those amounts been returned?
No, not yet.
If the letters of credit are paid by the issuing bank to Medallion, what happens to ARM's debt on its balance sheet?
When letters of credit are drawn, those amounts now become funded debt. Funded debt goes onto the balance sheet as debt, also goes into our covenant calculations as debt. Letters of credit do not go on balance sheet, nor are they counted in our covenant calculation with our credit agreement.
And when you say funded debt, what does that mean?
Funded debt are amounts that are not contingent or standby letters of credit. They are actually funded, actually drawn amounts.
Okay. And when you say it affects a covenant, can you describe to the court what you mean about the covenant?
Yes. Under our current credit agreement, letters of credit are excluded from the funded debt numerator of one of our covenants, the denominator being an earnings calculation. So if letters of credit become funded, that then increases the funded debt calculation. So your funded debt increases materially if and as letters of credit are drawn. And
how would the drawing on the letters of credit, $19 million going to debt, how would that affect ARM's trade credit?
In two ways. One is that if that funded debt calculation increases to a figure that then upsets our covenant calculation where we are in default on a covenant, that default being in default does not allow us to access our credit facility. We need access to our credit facility to do our day-to-day business, which as you just called, is trade credit, post letters of credit for our day-to-day operations of buying and selling commodities. If we cannot access our credit facility, we damage our business because we can't participate in those day-to-day operations of posting credit. That's the first, is the debt. Second would be, as that funded debt goes onto our balance sheet, regularly our trade counterparties review our financials for our financial wherewithal. Oftentimes they review our financials to do this. This is very common in the industry because as you buy and sell hydrocarbons, your balance sheet strength is something that counterparties focus on. So if a counterparty were to see a material increase in our funded debt, they could potentially ask for additional credit support. And that causes what we call in the industry a death spiral, where one trade creditor requests it, then another, and you simply can't keep up with the posting. If that were to occur, our trade credit will be materially shrunk, and we would be in that death spiral of not being able to post trade credit for our day-to-day operations.
How would that affect the functioning of the business?
Well, we start to lose function. If we can't post credit, again, this is a day-to-day thing. This is a very normal course of operations in the entire energy space. As you buy and sell commodities, you're talking about large dollars and large quantities. A counterparty wants to know you have the financial wherewithal to pay them if and when you buy and sell the commodity. So if we can't buy and sell that commodity, That's all. That's what we do. We're not a market anymore. We can't be. We're not ARM Energy Marketing. We're nothing.
Is the harm to the trade credit and the harm to the ability of the company to function a necessary or at least a probable consequence of the drawing on the LCs?
I think this significant figure is. The short answer is yes. This would be a significant enough figure for a company of our size to concern the ability to access our credit facility and potential trade counterparties to do business with us with a significant increase in our funded debt.
You mentioned trade counterparties. How does the drawing on the LC affect the business reputation of ARM?
Again, as those trade counterparties review our financials, they see a significant increase in funded debt, which means less liquidity. Less liquidity creates a cascade of consequences for a participant in the oil and gas marketing space. That's that death spiral I was talking about. We've seen it all across the industry. Any oil and gas marketer can tell you a story about a death spiral that happened to another company when there was a liquidity issue.
And how, we're sitting here today on April 2nd, 2021. We had the winter freeze event in February of this year. Did the winter freeze event, did that lessen the risk of irreparable harm, or does that heighten the risk?
The timing is unfortunate because during the winter freeze in February in Texas, which unfortunately probably a lot of you were impacted by, the market, because of the price of hydrocarbons during that kind of black swan event, the market went to a much more credit intensive business. That is, a lot more counterparties asked other counterparties to post either cash or credit because of the significant ramp in price. Because the total value, the P times Q, the price times quantity increased so rapidly that February issue has created, for lack of a better word, a hangover in the oil and gas trade credit space. So we have not yet, outlasted that hangover of trade creditors requesting materially more counterparty credit. So the long way to answer to your question, but it's important to know, it's not gotten easier because of February. It's gotten materially harder.
So after the follow-on effects from February of this year and the winter storm and the other risks that you identified with respect to trade credit and business reputation, does the drawing on the letters of credit pose a risk to ARM as a going concern?
Yes, that is my concern. Exactly. It does pose that risk.
Okay. If the March 29th termination by ARM was proper, based on your understanding of the agreement, what amount should be drawn on the letters of credit?
None.
What should happen to those letters of credit?
They should be returned to us.
And are you aware of whether or not ARM intends to re-terminate the agreements if the court has concerns about whether all of the procedural mechanisms were followed in the initial termination?
Richard, repeat that.
Yeah, I'm sorry. That was a convoluted question. I apologize. The court has expressed some concern about whether the prior correspondence between the parties. Do you know whether ARM is intending to re-terminate the contracts in the next 30 or 60 days if the court requires us to?
We can.
Okay. And do you know whether ARM intends to?
Well, we just terminated, but we would.
I thought that you guys already re-terminated it, no?
Yes, Your Honor, we terminated on March 29th, and based on the concerns you expressed on March 30th, we issued a second notice to them on March 31st, which is Exhibit 27, which indicates that we are going through the process again of re-terminating, assuming that you maintain the finding that the October letter may not have sufficed.
Okay. Go ahead.
Mr. Christopher, if the re-termination occurs in the next 30 days, what amount would be due to Medallion under the trade and transportation and terminal agreements?
Approximately $1.2 million.
And is Medallion secured for that period?
I would say yes.
Why do you say yes?
Well, Medallion has the $14 million payment deposit that I mentioned earlier in this discussion. That's certainly sufficient, at least in my rudimentary arithmetic, to cover a $1.2 million monthly charge.
And just to clarify, is ARM in arrears in any way for any payment owed to Medallion under these agreements?
ARM is not.
Okay. Do you have an understanding of whether or not Medallion intends to withdraw on the letters of credit if the request for temporary injunction is denied?
I believe they do.
And to your knowledge and based upon your experience as a chief financial officer and an executive in this industry, do you believe that Medallion would be harmed by leaving the letters of credit in place with the issuing bank pending a trial on the merits?
No, they are not.
Why not?
Medallion has sufficient protection, I might argue overprotection, based on what I just said, which is that $14 million prepayment is significantly, almost 10 times in excess of the next month's figure of 1.2. So no, I do not.
As the chief financial officer of ARM, do you believe that damages would fully satisfy or compensate ARM for a loss associated with if Medallion went and drew on the LCs today or next week?
If they remain as LCs, no. But if they are drawn, I have a concern about that debt spiral I mentioned. You have an issue with the covenant, or a potential issue with the covenant, and you have a trade credit run on the bank or debt spiral. Those are the reasons I get concerned.
Okay, and I don't want to know about an issue that is speculative or that could has a very remote chance of happening. I want to know, do you think it's probable that ARM would be irreparably harmed if there's a draw on the letters of credit?
The figure is sufficiently large that yes, I do.
Pass the witness.
All right, cross. And this will count against the defendant's time.
Medallion holds the prepayment funds because that's what the contract requires, does it not, Mr. Christopher?
I agree.
And the letters of credit that have been posted are there because ARM agreed to provide that credit assurance, correct?
Yes, sir.
And there is a shortfall between what is required under the contracts that ARM entered into and what's now present because Glencore terminated its guarantee. Is that not correct?
I don't see the shortfall, sir.
What's a mystery to you about the shortfall, the 12 million or so shortfall in credit assurance that's due to Medallion?
ARM has terminated this agreement. So the credit support should be returned.
Okay, let's assume that it hasn't terminated this agreement. It's not entitled to terminate this agreement. You would agree that the credit assurance is deficient per what ARM agreed to hold to post as credit assurance, correct?
I'm not sure I agree. I apologize. No.
Did you get a copy of the March 23 letter from Medallion specifying what the shortfall was?
I have that. Thank you.
Did you contact Medallion and tell them that that was not the correct amount?
No, I did not contact them. But that figure, I think it was 12.3. It didn't have a calculation to it. So I don't know how to assess that.
Well, you can go to the transportation services agreement and the terminal services agreement and figure it out, can't you, sir? It's pretty clear how you calculate it. Is it not?
I don't think so, no. If it was clear, I would expect it to be attached in their addendum.
It was attached as an addendum. Did you not see that, sir? How the calculation is
No.
done?
No.
What you've described about this parade of horribles to that, as you cast it, to ARM about financial covenants and funded debt and so forth, that's normal financial operations for an oil and gas company, is it not?
It is not normal operations for an oil and gas company, no.
Well, debt covenants are not, are you saying debt covenants are not a normal part of a oil and gas company's operations?
Debt covenants are. I think what you described was the parade of horribles for an oil and gas company. First of all, we're not an oil and gas company. We're a marketer. There's a bit of a difference. Covenants are a part of the daily life for oil and gas companies, marketers, and most companies, frankly.
And by trying to stop Medallion from drawing on the letters of credit, isn't ARM saying that it wants Medallion to help it out in a way that the contract doesn't provide because ARM thinks it has a risk given its financial condition? Isn't that what you're saying?
No, I think we're saying we're terminating, have terminated. I know that there was some dispute as to the notice, and as such, we would like our credit support back.
Let's assume that you're not entitled to terminate. Aren't you asking for a handout?
Sorry, I can't make that assumption, sir, because we are. So I beg your pardon.
Has Glencore, has ARM posted the additional credit assurance that's called for in the agreements?
Yes.
The additional credit assurance that's called for in the agreements, are you saying here that in response to the termination of the Glencore guarantee and the request from Medallion to post the additional $12 million in credit assurance, are you saying that ARM has posted that?
I'm sorry, I beg your pardon. No, I think I misunderstood your question.
Okay.
ARM has posted the 14 million.
No, I'm not asking about the 14 million. I'm asking about, have you posted the additional amount that's due if you have not terminated?
We have not posted the 12.3 that you requested.
Is there some reason why you've been, that amount, assume that's the correct amount, that amount's been owing since March 19, correct?
I'm not sure we agree, sir.
Well, Glencore's guarantee was terminated on March 19. That amount has been owing since Glencore terminated its guarantee for its subsidiaries' liabilities. So since March 19, that amount has been owing. My question is, why haven't you posted the additional credit assurance that you agreed to post in the transportation services agreement and the terminal services agreement?
I think the answer to your question is we have a disagreement that we've terminated and that we're due our own 14 million and 19 million of cash and LCs. So I think that we are taking a different position, sir. I beg your pardon.
About those two letters of credit that secure the transportation services agreement, is there anything in either of those that says Medallion may not draw on those letters of credit if ARM claims it will cause it injury with its creditors or its business operations?
I don't believe so.
Pass the witness.
Just two follow-up questions, Your Honor. Mr. Patterson cut you off a number of times. I wanted to ask you what additional credit assurance is required to be provided to Medallion if the agreement terminated as of March 29th?
I don't see any.
And what additional financial obligation is owed to Medallion if the termination process has to be restarted on March 31st and there's another termination on April 30th?
Fair enough. If there's another month to pay, then that's approximately $1.2 million.
Okay. And does Medallion already hold in excess of $1.2 million in cash from ARM?
They hold that 14 million, roughly 14 million that I mentioned earlier. Yes.
Thank you very much. Pass the witness.
Mr. Christopher, if ARM did not terminate on March 29th, what credit assurance do you believe is due?
It's a hard question to answer, sir, because we did. So
No, my question is, assume that you did not.
yeah, I don't know the answer. I don't have an answer for you. I beg your pardon.
Nothing further.
Okay. Call your next witness. How much
Yes, John.
time do they have left, Samantha?
Right now, we're at 16 minutes and 15 seconds.
They've
Okay,
used, or
good.
that's what they have left?
What they've used.
Okay.
Okay, Judge, I need just one quick minute, please.
Okay. Don't count the time now.
Your Honor, I took your very clear instruction to heart, and I will do my very best to give you time back.
Right. Is Tony back? I don't see it now.
I apologize. I'm ready.
Okay, call your next witness.
Yes, Your Honor. Plaintiff ARM Energy Management calls Scott Wishoff.
Okay. All right, sir, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
You may proceed.
Mr. Wishoff, what's your title?
Senior Vice President of Marketing.
And you're a Senior Vice President with ARM Energy Management, the plaintiff?
Correct.
And could you please very briefly describe for the court what ARM is in the business of doing?
ARM Energy is a producer services company, which at its heart means that we work with producers to get their barrels to markets, and ideally receive the highest revenue for their product.
And what is Medallion's business?
I believe Medallion is generally a pipeline gathering and transportation company, which moves barrels or MMBTUs, hydrocarbons, from one point to another.
Okay. The transportation agreement that is admitted as exhibit number 1 describes or provides for transportation on a pipeline. What pipeline is that?
It is the Medallion pipeline within Epic Pipeline.
You say the Medallion within Epic. What is Epic Pipeline, and what's the relationship between Epic and Medallion?
Epic Pipeline is a crude oil pipeline that moves oil from the Permian Basin of West Texas to Corpus Christi, Texas. Medallion, it's an integrated system that combines parts of Medallion's system and a long-haul pipeline from Medallion's gathering system in West Texas to Corpus Christi. It's a combination of those two pipes.
And when you say it's a pipe in a pipe, Could you describe for the court what a capacity lease is?
Capacity lease is where a counterparty, in this example, ARM, makes a payment or a lease payment to lease space on those pipelines.
Could you describe what rights Medallion has to use Epic pipelines so far as you understand it?
My understanding is that there was an asset swap that Medallion entered into with Epic. Medallion did some work for Epic and in exchange received capacity on Epic pipeline from West Texas to Corpus Christi, which in that state is what they re-released to us.
All right. In December of 2015, the United States lifted the crude oil export ban. How did that affect the marketing of crude oil from Texas producers?
So this was the first time that production within the domestic United States had the ability to go achieve the higher international price. Obviously, that is done by exports from the U.S. coast.
And is Corpus Christi one of the ports that provides exports of crude oil?
Yes, Corpus Christi has become one of the major ports in the United States.
And you mentioned that there's this Medallion and Epic pipeline that runs from the Permian to Corpus Christi. What rules or documents govern how movements on a pipeline are done?
It's operated under a filed tariff. We operate under the Medallion tariff.
All right. And what is a tariff? Could you explain that to the court?
Tariff is the general rules and regulations on how the pipe will transact business, conduct business, and the rules that we are to follow when we sign that agreement.
All right. And could you describe for the court the ship or pay commitment that ARM Energy makes to Medallion under Exhibit 1, the transportation agreement?
ARM entered into an agreement with Medallion. I'll use round numbers or non-approximate numbers, but for 850,000 barrels for the month, we will pay them a fixed payment each month for the right to move those barrels. Whether we use them or not, we will make that payment.
Okay. And once those barrels move from the Permian Basin to Corpus Christi, what happens to them?
There's the terminal at the end of the pipe. It's the dock in Corpus Christi that then we then pay to move those barrels from onshore onto a vessel.
Whose terminal are these crude oil barrels delivered to?
It is the Epic terminal in Corpus Christi.
Okay, and again, you told me about the relationship between Medallion and Epic on the pipeline. Is there a similar relationship between Medallion and Epic on Epic's terminal in Corpus Christi?
That is correct. We are contracted with Medallion.
Okay, and so does ARM have a direct contract with Epic?
No, only Medallion.
Okay, and so who does ARM look to secure performance of the obligations called for under the contract?
Medallion only.
And the terminal agreement that's Exhibit 2, could you give an overview to the court of the obligations of Medallion under that terminal agreement?
The terminal agreement put in place was for one monthly loading of one vessel for 1 million barrels.
Why was it that ARM sought to load a marine vessel that could hold up to 1 million barrels of crude oil?
In the crude oil international shipping, while we are not the utmost experts in international shipping, we partnered with Glencore, who is. It is a bulk scale process where the more you can move in each movement, the shorter you can move, the more you can move, the better economy of scale there are for your business.
And so why is a 1 million barrel vessel preferable to a smaller vessel of 600 or 700 or 800,000 barrels?
If you're moving less barrels, the idea is to get the maximum barrels onto a VLCC. You'd like to move 2 million barrels on a VLCC. 1 million at a time is easy. If you start to go 300, 400, 600s at a time, it becomes very costly, very prohibitive. So the ideal scenario is not to be in that situation.
What is a VLCC?
I'm sorry, I meant to say vessels. A VLCC It stands for a very large crude carrier. It's a big ship, essentially.
And how are VLCCs used in international commerce in the sale of or transportation of different grades of crude oil?
Those large ships are used to ship that product across the world.
And ultimately, those ships arrive at a port in Europe or Asia or somewhere else, and they are used how?
They are offloaded and to various refiners, various end users in various parts of the globe.
Okay. Now, the terminal agreement you said provides for a 1 million barrel ship. Does it also provide for different grades of crude oil?
Yes, our agreement and the medallion tariff has a common stream 1, which is commonly referred to as WTI, and a common stream 2, which is referred to as WTL or WTI light.
And what does WTI stand for?
West Texas Intermediate.
And what does WTL stand for?
West Texas Intermediate Light. So it is a lighter product than the WTI product.
And when you say it's lighter, does that mean, what does that mean physically or from its characteristics?
There are different characteristics. It's a lighter quality. And why that is important is because the WTI and the WTL products are used, whether domestically or abroad, to make different products. If a refiner in Japan wants to make more jet fuel, it may use WTI. If they need more gasoline, they may request WTL. So each of these products are in different demands and different values over time.
Why was it important? Well, I guess I should ask you this. Did you participate in negotiating the terminal and transportation agreements?
I was a participant, yes.
Why was it important to ARM to secure the ability to transport those 2 different grades and to load those 2 different grades onto ships?
We have clients that both have WTI and WTL. Some clients only have WTL, some have only WTI, some have both. It was very important for us to have the ability to move both qualities to get the best price for our customers. It was very important to have a 1 million barrel boat vessel to have the best price for our customers. And that is the reason why we signed up on this deal.
Well, why can't you just mix them together?
There is a possibility of mixing them together, but they each have a different value over time. And so once again, if an Asian teapot is looking to make gasoline, they may pay more for that WTL product. They do not want them mixed together. And not to get into a lot of jargon, et cetera, in this time frame, but end users want quality. They don't want mixed products.
Do they have different market prices, the 2 different products?
Yes, they both float depending on the supply and demand of the market. So there have been times when WTL has been very, very cheap versus WTI, and there's been times when it's a premium to WTI. But there is a wide range of that value over time.
And are they traded publicly or at some general contract locations?
Yes, they each have pricing components. Argus prints them, other publications print them, etc.
All right. Were the 2 agreements, the transportation and the terminal agreements, were they interrelated?
Yes.
Do they provide, do you know whether they provide for cross default?
Yes, they do.
All right. Between the time the contracts were signed and the time of the October 2020 letter that we've talked about, did Medallion perform its obligations to provide a 1 million barrel vessel?
We've never received a 1 million barrel vessel.
Did ARM and its partner Glencore request a 1 million barrel vessel?
Yes.
And did ARM and Glencore request the ability to transport WTL crude under the transportation agreement?
Yes.
And was that request to transport that product accepted or rejected?
Rejected.
Did you participate in drafting the October letter to Medallion regarding the service failures?
Yes, I was a participant.
Okay. And why were you involved in that process?
We were documenting our partnership with Glencore, the lack of tariff guaranteed situations that were not being performed. So I was the business counterparty on ARM side, describing the services we are not receiving.
Okay. Your Honor, if I may, I'd like to be able to share my screen. Mr. Wishoff, I'm showing you now a document that's been admitted as exhibit number 10. And want to focus first on this issue of the origin and destination points. Do you see this portion of the letter?
Yes.
Is this the October letter or something else?
Yes, sir. This is the October 2020 letter.
Okay.
And this letter on page 4 identifies what is supposed to be provided with respect to the origin and delivery points. Do you see that I've highlighted?
Yes.
And why was ARM and why were ARM and Glencore telling Medallion about the requirements under the contract that it thought hadn't been fulfilled?
Common Stream 2 has not been allowed to flow since day one. It is in the tariff and it's not been accepted.
All right. And with respect to the issue of the Robstown delivery point, was that something that was that a destination that was not allowed by Medallion?
30 minutes
Robstown-
left for plaintiff.
Would you say 30 minutes?
30 minutes.
Okay.
Robstown is a destination point on the contract. In a time of emergency, there was unfortunately a barge that sunk in front of the Epic terminal. Glencore, as the contract owner, requested to move the barrels to Robstown, which were a destination on the contract, and it was disallowed.
So with a barge sinking in front of the Epic terminal, were Medallion and Glencore, were ARM and Glencore able to use the terminal during that time?
The terminal was unavailable and our destination points on our contract, Robstown, was unavailable as well.
All right. And what remedy was requested from in this October letter with respect to Robstown?
The Robstown, it was that we should be able to use it, and that we should be able to any cost be recouped because of it, I believe.
Okay. And after sending this letter, was the Robstown issue fully and satisfactorily resolved by Medallion?
I don't believe that it's been an issue since.
Okay. With respect to the shipment of Permian Common Stream 2, also known as WTL or West Texas Light, why does this letter identify that as a breach?
As I mentioned earlier, since the inception of this pipe, the Common Stream 2, we have not been able to use. It has been rejected.
Okay. And at the bottom of this section of the letter, it states, quote, until such time customer contends and requests that Medallion acknowledge the customer is permitted to ship West Texas Light crude under the Transportation Services Agreement. Do you see that I've highlighted?
Yes.
And in the later months of 2020, so November and December, did ARM and Glencore attempt to ship West Texas Light, and was that accepted?
It was not accepted, and Glencore does continue to ask each month if WTL will be accepted, and the answer is always no.
Did Medallion reject ARM's request that Medallion agree that it could ship WTL as provided for under the contract?
Yeah. So just small clarification: it's Glencore. They rejected Glencore's request.
Okay. And Glencore was ARM's partner with respect to making the nominations?
Correct.
And I want to highlight the issue about the 1 million barrel ship. Here in the letter, it states that, quote, customer is entitled to one firm vessel per month with a capacity of up to 1 million barrels. And it cites the section of the contract that provides for that. Do you see that?
Yes.
And it details below what has been provided, which is vessels of approximately 720,000 barrels. Do you see that?
Yes.
Okay. Tell the judge exactly what happens if you are able to load a 1 million barrel vessel, but then you're only allowed to load a vessel of 720,000 barrels. What happens to the extra 280,000 barrels?
So our partner Glencore is then what we call long. They have additional barrels at the end of the pipe that they are not allowed to load. And Medallion is then charging Glencore to store those barrels. So not only can they not take them, they're not helping them resolve the issue, they're actually charging them for that differential.
So on top of not being able to use 1 million barrels, the additional barrels just have to sit there and you have to pay storage. Is that what you're saying?
Correct.
Why wouldn't Medallion provide the storage for free if it's not living up to its obligations for the 1 million barrel ship?
It's a great question.
Okay. And here the letter says at the bottom of this section, there are several ways that Medallion can resolve this issue. Do you see that?
Yes.
Why were you asking Medallion to resolve this breach?
We were asking them to resolve it. As we stated, the tariff states that we can flow common stream 2, that we can load a 1 million barrel vessel. That is what we signed up for, and that is what we wanted. So we wanted Medallion to resolve it. To be clear for everyone, they were in breach day one. When this pipe went into service, we have never been able to receive these services that we signed up for. So we worked with them a long time until this letter. Then this letter went out, and we asked them to resolve them.
And after sending this letter, why is it that you were asking them in the letter to resolve or cure this breach that you identified?
We needed this to be resolved. This is a harm to our company. This is not what we signed up for. And we need the 1 million barrel ship, and we need at the right location, and then we need the ability to move our WTL because it's affecting our business.
Okay.
Let me ask the witness a question, because I think this is my fundamental issue with this letter is, where in the letter does it indicate that this contract is terminated?
Judge, respectful question. I'm not a lawyer. So to me, I read this as this is our plea. This is our saying, this is in breach. We need it resolved.
Because that's how I read it too. I read it as you have all these issues, you want them to fix it, but you haven't terminated the contract.
Your Honor, if I may, we don't contend that this letter terminated the contract. We contend that this letter put them on notice of breach. And then after they were on notice of breach, they had a time period to cure. And if they didn't cure in the specified time period, then we were able to terminate.
Okay. Go ahead.
All right. All right, I want to turn to what happened after this October letter went out. You mentioned that there was a request to nominate WTL at later times. I want to look at 2 of those briefly. First, I'm showing Exhibit 17, which is a December 10th, 2020 email from Matthew Hubert to Veronica Leland at Epic. Matthew is one of the employees of your company, correct?
He's an ARM employee, yes.
And he works on your team?
Yes.
And Miss Lewand at Epic was the person to whom Medallion instructed ARM to make nominations. Is that correct?
Glencore, yes. Glencore and ARM, yes.
And what response did Epic, who was the designee of Medallion, say in response to our request to use WTL service?
They're not accepting it.
All right. On the issue of the 1 million barrel vessel, I want to show you an exhibit that I shared this morning, and I'll zoom out a little bit. This is an email from Mike Lassman. He was here this morning, but for some reason has had an issue. He can't be here this afternoon. Who is Mike Lassman?
Mike Glassman is my counterpart at Medallion.
And he sent this email to you. That's your email address at ARM.
Correct.
And who's Guy Freshwater?
Guy Freshwater is Glencore's commercial contact representative in this issue.
And when was this email sent?
February 9th, 2021.
Okay. And Mr. Lassman copied his legal counsel. Is that correct?
Correct.
So I want to look first at the issue of this million barrel vessel issue. What did Mr. Lassman tell you about the ability of Epic and Medallion to be able to load the million barrel vessel at their existing dock?
They were unable to load that on that dock.
Do you know why?
The dock, when the contract was signed, they were building a new dock in Ingleside, which they have never done. So now they're at the existing dock, which is never going to be able to deliver the 1 million barrel vessel load.
Let's say that the court required us to re-terminate and give another cure period. Could Epic and Medallion fix the issue? Could they make their dock deep enough to allow for a million barrel vessel to be filled within the next 30 to 60 days?
No, and this email says as much.
What did
20 minutes left.
Thank you. What did Mr. Lassman tell you about what will happen when the second dock is completed, if it is?
It'll continue to have the same characteristics. It can maybe load up to 750.
And I want to ask about this third point. He says Epic's position on the 1 million barrels language continues to be that their obligation is up to 1 million barrels, a point that only attorneys can argue. What did you understand from his comment?
That is definitely a legal comment that Mike and I were not going to resolve. I think he is saying they are not going to be able to give the million barrels. And to use an extreme example, the up to means that they could also deliver, say, 1 barrel vessel, which was not the intent of the contract.
He also says at the bottom that they may be able to secure space at Pin Oak Terminal. Is Pin Oak Terminal a terminal that is provided for under the contract?
It is not.
Is Pin Oak Terminal acceptable or unacceptable, and why?
Pin Oak was denied by Glencore. Glencore had their reasons. Pin Oak is not a replacement for the new terminal that was to be constructed at Ingleside, which would have been a superior facility, which is why we wanted to operate there. This is in the Corpus Christi ship channel, and that is not what we were looking for when we signed this contract.
Could you explain to the court the relative location of the Pin Oak Terminal versus the new terminal that Medallion?
Just so you know, I'm actually from Corpus Christi, so I know all these areas. Just
awesome. Fantastic.
I don't know where Pin Oak is, but I know where Ingleside is. I know where Corpus Christi and Robstown are.
That's good.
Where's Pin Oak?
So Pin Oak is within the Corpus Christi ship channel.
And why is that undesirable compared to Ingleside?
Ingleside is under the Port of Corpus Christi's authority, but it is not on the Corpus Christi ship channel. It has superior location as it is outside of the channel. It will be dredged sooner. There are advantages to being out there, the turnaround, the loading at night, et cetera. So when we were signing up for a contract, we were not looking to sign a contract on the Corpus Christi ship channel.
Did you pay a premium when you signed this contract?
We paid a price that we thought was we paid a price that we thought was a fair price to move multiple grades and to have a superior dock.
There has been some suggestion by Medallion that this is just an effort to get out of this deal and renegotiate the financial terms. Have you ever asked Medallion to lower the price or otherwise change the deal, or are you just trying to get Medallion to live up to the bargain?
Not once. We've only asked them to provide the services contracted.
Okay. Did you have regular meetings with Glencore, Mr. Freshwater, and others about the breaches and efforts to cure these breaches?
Yes, I had a standing call with Guy Freshwater and his team. As we discussed, maybe not in depth here, they were the contracted entity. They made the nominations. They hired the vessels, et cetera. So we had a weekly meeting to give updates on how it was going.
And at any point in time, and with all of the various emails that ARM and Glencore had with Medallion, were the issues that we've discussed regarding WTL service and the 1 million barrel vessel service, were those ever resolved at any time after the October 2020 notice of dispute letter?
No.
After Mr. Lastman, your counterpart at Medallion, told you that they were never going to be able to live up to the contract terms, what decision did ARM take with respect to continuing these contracts or terminating them?
At that time, we had to bring everything onto the table. I think at that time, we had not made a decision. I know that Glencore had kind of thrown their hands up and they said that we're never going to get what was in this contract that we signed. And so Glencore had notified us that they were not going to extend our contract together with them. And so at that point, we had to start making decisions on what are we going to do next. We've been asking for help and we've been getting no remedies.
One point of clarification on the WTL issue, I don't think I asked you this. Which party, Medallion or ARM, is required to provide line fill for WTL service?
Medallion is presumably to require the line fill. It is not an obligation of ARM or Glencore, as it were, to provide line fill.
Okay. In March of this year, so the last 2 weeks, what action did ARM take to terminate the relationship with Glencore and terminate the relationship with Medallion?
The Glencore contract between ARM and Glencore and Medallion was terminated, which was then put back to ARM. Glencore, we paid Glencore for the remainder of February and all of March, and then it was terminated at that point.
Okay. Has ARM Energy paid all amounts due under the transportation and terminal agreements through the end of March?
Yes.
And on March 29th, what did ARM elect to do after all of Medallion's defaults, after being told that they will never be able to perform? What action was taken?
I can't remember the sequence of timelines, but there was a termination notice was sent.
Okay. After a termination of these agreements, what is Medallion obligated to do with respect to the $14 million in cash that it's holding and the $19 million in letters of credit that are sitting out there by First Horizon and Iberia?
I'm not a lawyer, but the way I read the contract is those were to return back to us.
If for some reason the court were to determine that the March 29th termination notice that was sent after all of those efforts to try to get a resolution from Medallion was for some reason improper or didn't comply procedurally with the contract, is ARM intending to re-terminate the contracts after giving a new notice?
Yes.
I want to show you what's been marked as Exhibit 27. Do you recognize this letter, Exhibit 27, as a letter to Medallion?
Yes.
And does this state um, ARM's intentions with respect to the continuation of the agreements after, if the court were to find that the March 29th termination was not effective?
Yes.
Okay. And what, why does ARM want to maintain its termination on March 29th or re-terminate after giving another cure period?
We have not received any of the services that we've requested for in these payments. So we intend now to terminate, whether it be October 5th or the termination on March 29th.
Okay. And obviously you're not a lawyer, you're not a judge, and I'm not asking you to be either, but do you believe, sitting here today, that Medallion was provided an opportunity to be on notice about what the alleged defaults were and to try to have an opportunity to resolve them with Glencore and with ARM?
Yes, they definitely understood them, and it was discussed many, many times throughout, starting on April 1 through today. That has definitely been on notice, under discussion, etc.
When you say April 1, are you referring to April 1 of last year?
I'm sorry, all the way back when the pipeline started. The pipeline went into full service without being able to provide WTL service, common stream 2, or having the 1 million barrel dock. They still went into service at that point.
And that was in 2020?
Correct.
10 minutes left.
All right. Your chief CFO testified about his view on the effects of drawing on the letters of credit. From your perspective, in your different role with the company, can you articulate to the court your concerns about whether there would be just purely a financial injury or whether there would be irreparable injury from Medallion's drawing on the LCs?
From a business perspective, the concern I have, as I've lived through two of these through different time periods, is you guys refer to as a death spiral. I guess on my side of the business, we refer to it as a run on the bank. And it may not even be a change necessarily in your company's ability to continue to do business, but it could be a loss of confidence. So my concern would be that there is a change in confidence that creates quote unquote run on the bank. That would be my concern.
And how would it affect the business reputation and your ability to trade?
A lot of what we do is credit-based business. We have customers that sell to us unsecured because they trust us and believe in our business. And so loss of confidence is a tough thing to shake.
And how would keeping the existing LCs in place with ARM maintaining them and with Medallion not drawing on them, how would that keep the status quo that exists today?
I believe, if I understand the question correctly, that leaves, I think you just said it, that leaves the status quo, and the courts and we can decide what to do next, but there's no crisis of confidence, if you will, created.
Even if termination has not already occurred, if for some reason the court were to find that and termination happened in 30 days, is Medallion undersecured with respect to the financial obligations owed between now and a re-termination in 30 or 60 days?
I think that was, you guys have had some questions on that. I would tend to agree that the 14 million covers the 1 month of payment.
Pass the witness.
The credit assurances are not to cover the next month, are they, sir?
The credit assure, that's not necessarily my department, but
Well, you've just been testifying about it. The credit assurances are not to cover the next month, correct?
Well, credit assurances for what time period?
The credit assurances here are to cover the entire 5-year term of the agreement, correct?
There were credit assurances placed at the beginning of the contract to cover the contract, yes.
The entire term of the contract.
Yes.
So if Glencore has withdrawn, has terminated their guarantee, credit assurances are not sufficient for the entire term of the contract, are they, sir?
Once again, not my department. I think I would at least say that we terminated the contract. So I think at best it's up in the air.
Let's assume you didn't terminate. You got the letter from Medallion saying you needed to post an additional $12 million of credit assurance. In fact, Mr. Wishoff, when Mr. Lastman called you and told you the letter was coming, didn't you tell him, yeah, we know we need to post more credit assurance? Didn't you tell him that?
With all due respect, that was not what I told him. We had a conversation about 3 different items. How would this affect operations? We said there was no change. We talked about when was Medallion's date of termination. Were they on the hook through the 19th or through the 31st? I told him they were through the 31st and they would make payment as is. And then with regard to the additional credit, we acknowledged it. And I said, we need to get our ducks in a row and we'll call you next week.
Did you?
No, you guys sent a letter to us saying you were going to pull on the LCs. And so over the weekend, my management decided it was time to terminate.
Let me step back for a moment, Mr. Wishoff. Has ARM ever actually flowed barrels on its own account on the lease pipeline?
No, it was Glencore. Glencore faced Medallion.
And in fact, since Glencore stopped, since you terminated the assignment to Glencore, has ARM flowed any barrels of its own?
Well, it was Glencore was responsible all the way through March 31st.
Okay. Has ARM made any nomination to flow barrels in April?
No, we have not.
Now, when you testified about whether this was a competitive deal, and I think you said that it was a competitive deal when you signed it up in 2019, July of 2019, correct?
Correct.
And what were you paying for transportation and terminal fees back in July of 2019?
On this deal specifically,
Yes, sir.
is $1.50 from origin point to vessel loading.
And what's the cost today, the market cost for walk-up service today?
From origin point to vessel loading, let's say between, and it fluctuates obviously, could be 30 to 50 cents.
Substantially less than what you're paying, right?
That's correct.
And are you sure that's not why we're here today? Did you just want out of it because the economics have turned around?
I could tell you that we have worked with Medallion since the beginning to get the services fixed, and we have not asked for a lower rate. And I can also tell you that we have many other contracts at our company, including DAPL Pipeline, which may shut down, who have substantially lower rates, and we've not asked to get out of one of them.
Let's talk about something you said about Corpus Christi. Corpus Christi is not just a port, is it?
I'm not sure I understand, please.
Well, Corpus Christi is not just a port facility. Corpus Christi has refineries and other outlets for crude oil, does it not?
Yes, it is an industrial complex.
I want to focus with you, Mr. Wishoff, on the transportation services agreement, because that's the agreement that secures the 2 letters of credit at issue here. Mr. Downs, would you please pull up page 103 of our exhibits? We need to share the screen, Your Honor.
Fine.
This is in Defendant's Exhibit 18, the transportation agreement. And go to page 103, please. Okay, there we are. If ARM or Glencore were going to declare a carrier default, which is what you maintain that October 5 letter was, Section 603 defines a carrier default, right?
There's a definition of carrier default. I agree.
And then Section 604A specifically says that on the occurrence of a carrier default, shipper may provide written notice to carrier describing the carrier default in reasonable detail and requiring carrier to cure the carrier default notice. Do you see that?
I see your highlighted area. Yes.
So it's a written notice that describes the alleged carrier default in reasonable detail and requires the carrier to cure the carrier default, correct?
I read that. Yes. In A.
And it has to be within 30 days, right?
I see that. Yes. I read B.
All right,
highlighted.
let's go to page 111 then. It talks about a notice. Let's go to page 111 on the notice provisions. Section 15.08. The notices, it says, have to be in writing, addressed to the party receiving the notice at the address set forth below and sent by personal service or by email, correct?
I see that in writing. Yes.
And here that means to Medallion, attention, Randy Lentz, correct?
I see your highlighted. Yes.
With a copy to the legal department, right?
I see that. Yes.
Mr. Lentz is the CEO at Medallion, right?
I understand that. Yes.
Let's go to some of these emails that Mr. Howell showed you. Let's go.
Wait, can you go back to 6.04 again?
Yes, sir. Mr. Downs.
So I'm trying to kind of understand so it requires that they provide written notice to the carrier describing the carrier default in reasonable detail, inquire carrier to cure carrier default. And then it says if the carrier has not, under B, if a carrier default has not been cured within 30 days after receipt by carrier of carrier default notice, then let's see, what does it say? Then in such case, in such case, shipper may by written notice to carrier terminate this agreement, any such termination to be effective upon receipt of the applicable notice by carrier. So is your argument then, Mr. Howell, that the October letter was supposed to be what was under A, just providing notice? It wasn't supposed to provide termination?
Yes, Your Honor, precisely.
And then when was the written notice of termination sent?
After the cure periods, so it says 30 business days, which is about 60 regular days. So that was the efforts in November, December, January, February to cure. And after all of those were unsuccessful, there was the March 29th notice terminating it effective immediately.
Okay, so and so the note, and then after the cure, but it never says anywhere in the letter or the original letter that they have 30 days to cure, right?
It does not, Your Honor.
It does not say 30 days to cure. It says we request the following remedy, or we request the following action be taken by Medallion. It does not say 30 business days to cure. But in section 6.04A, it says you have to detail the carrier default and you have to require carrier to cure. It doesn't say you have to tell them of the 30-day period. And there's obviously no question that we provided more than 30 days.
Okay, all right. Go ahead.
Mr. Wishoff, let's turn to, with that in mind about what's required for notice, let's go to ARMS Exhibit 17 that I believe Mr. Howell showed you. And this has to do with the WTL nominations at Orla. Ms. Lewand at Epic tells Matt Hubert at ARM that we are not accepting anything for January and still evaluating the timeline. Do you see that?
Yes.
Did ARM call Epic and find out why?
Well, this was not a surprise. This has been happening every month since the inception of
my
the contract.
question.
So I do not believe we asked further why that would be.
Do you understand, sir, that Epic's responsibility to take the crude is not just a function of what is expressly in the agreement, it's also a function of what's in its tariff?
As that regards to me, I think our ARMS contract, and when Glencore was acting on our behalf, it was with Medallion.
Right, but you understand that the contract is still subject to the tariff, correct?
Medallion's tariff, right?
Which incorporates the Epic tariff, correct?
It may reference. I don't know. I'm sorry. You're telling me it does.
Do you know if the reason Epic was not receiving anything for January is because the conditions in its tariff were not satisfied?
Not that I'm aware of. They hadn't been providing WTL service from April 1 onwards, so it's the same every month, I assume. They just didn't have the facilities to go into service.
But you didn't call and find out why, right?
Correct.
And do you recall that Mr. Lastman called and asked you if you wanted him or Medallion to dispute it? You recall that?
I don't, but we had a lot of conversations, and Mike has always been willing to work on it. Yes.
So my understanding is you never even responded to that. Why not?
To Mike's request?
Yeah. His offer.
So Glencore was facing the contract. So those conversations should have been happening between Guy and Mike, which I'm not privy to. That Guy may know exactly why they weren't loading in January.
So that's not something that you have any personal knowledge about, right? Because ARM had nothing to do with flowing the barrels. It was all Glencore, right?
Glencore was facing Medallion on the contract. Yes.
Let me ask you, does Plaintiff's Exhibit 17 describe the alleged carrier default in reasonable detail and require Medallion to cure?
Could you repeat the question, please?
Yeah. Does Exhibit 17 that we've been looking at, does it describe the alleged carrier default in reasonable detail and require Medallion to cure?
A lot of these, you guys are reading these things. These are lawyer questions. I think the only thing I can say is in October, we said, hey, services aren't being provided. We need help. We've then paid you and worked with you for the next 5 months to no avail. And I think that's why we're here. I'm not a lawyer. I can't comment on this.
Well, this morning, the court asked the question about what was the notice of default, and we're still looking for that here. If it's in any of these other documents that your counsel has asked about, this Veronica Lewand email does not satisfy the requirements for notice of a carrier default, does it? That we just looked at.
Objection, argumentative, objection calls for a legal conclusion.
You can answer if you can, but if you don't know, just say you don't know. You've done a good job with that so far.
Yeah, I don't know the legal parts.
All right, let's turn to another document that Mr. Howell used with you. It's AEM 20. Can we go to that, please? You talked about this, and let's start with 2 because that seems to be your big issue on Epic and the 800 and loading the volume onto one ship. Do you understand? And Mr. Downs, would you go to Defendant's Exhibit 19? It's at page 136. This is the Terminal Services Agreement. Page 136, please. Section 3.4, you passed it. Okay, there you go. Did you understand, sir, that Medallion's rights, which, you know, Medallion would be a shipper on this too, but it's assigned its rights to ARM and then consented to the assignment to Glencore, that the rights under this agreement, specifically section 3.4, is to schedule 1 vessel that cannot exceed a capacity of 1 million barrels. Do you see that?
Yes, that is my understanding. 1 vessel per month.
A vessel with a capacity of not more than 1 million barrels, right?
Correct.
It doesn't say that Medallion, or for that matter, ARM, can nominate 1 million barrels to a vessel, does it?
I believe that was the intent. And I think the intent of this line was to say, if we came in with 860, then we asked for an 860 vessel, or we asked for up to 1 million. But I think this was kind of Mike's joke that we had was, if that's the case, then you guys could give us a 1 barrel vessel, and that's not the intent either. So this is a legal comment, not for me to answer, but the intent was to be able to load 1 million barrels.
Well, what would anyone's financial incentive be to give you a 1 barrel vessel, sir? That's
agreed. Maybe not a fair comment. I would draw that.
Right.
Just say yes.
But the right that you had, that ARM had, was to nominate 1 vessel per month with a capacity of not more than 1 million barrels. It wasn't to nominate 1 million barrels to be loaded on a vessel, is it?
I would say that the commercial agreement, these are again legal words, but the commercial agreement for a guy that moves barrels from one place to another was that we want to move 1 million barrels from West Texas onto a ship. That was the intent.
Or anywhere else that you could sell it in Corpus Christi, correct?
That is our option. So our option is actually, we could even sell those barrels in Midland, but we're still paying for that MVC, or we could put it on a vessel and sell it in Asia. But that's our option. By paying that minimum volume commitment, that is the option we have now bought to transact throughout that value chain. Let's
go a little bit further into this document to Exhibit B on page 155. This is Exhibit B to the Terminal Services Agreement. All right, there we go. Vessel nomination. Mr. Downs, would you highlight there about halfway through where it says the Port of Corpus Christi? There you go. And keep going down to the provided, all right? Did you read this part of the contract as well? Mr. Wishaw, did you read this part of the
I'm
contract?
sorry, I'm reading it. The Port of Corpus Christi always handles these services, is my understanding.
And the channel at Corpus Christi cannot handle loading 1 million barrels on a ship, at least at this time, can it?
No, that's why you guys are in default, because you were supposed to build a new terminal over in Ingleside, and that's where the default has come in.
Well, that's assuming that a 750,000 barrel capacity ship is a ship that has a capacity of no more than 1 million barrels, isn't it?
That seems like legal wording.
Well, but it says here the Port of Corpus Christi handles nomination notices on a first come, first served basis. Medallion and its designee, Epic, have the right to refuse approval of a proposed nomination notice for reasons including the vessel nominated and proposed date range. So if Epic says you can't nominate, you can't put 1 million barrels on a ship because the port can't handle it, you agreed to that, right?
We agreed to a new terminal that was to be built that has not been built, is what the agreement was for.
But Epic has the right to refuse approval of the proposed nomination notices for reasons including the vessel nominated and proposed date range. You see that?
I think that's what, look, Glencore is handling this portion of it, so maybe I shouldn't be discussing it, but I think.
So you really
I think
don't
what-
know. Oh, I'm sorry. So
I
you
think
really
what
don't know, do
I
you?
think what this is saying, is when you nominate a vessel, you say, hey, Medallion, Glencore says, I want to load 1 million barrels at March 10th through 20th. And then there is a window that is given. It can be denied and say, we have no windows between the 10th and 20th, and we can show you on the 23rd. But you are guaranteed one vessel per month per this agreement.
One vessel of not more than 1 million barrels, and you have the right to nominate that vessel, right?
1 million barrels, yes.
And you do not have the right to nominate 1 million barrels to go on that vessel, do you?
We do. Per the agreement, we do.
Right. I think we've talked about that. Let's go to the second issue that you and Mr. Howell were talking about on the WTL. Do you understand that under Epic's tariff, it is not obligated to provide WTL West Texas Light service until several conditions are satisfied? Do you understand this?
I don't know if I understand that.
Well,
I have a contract with Medallion.
okay, but you're flowing on Epic pipeline. It's subject to Epic tariff, correct?
You said that, so I'm sure you're telling me the truth.
One of the conditions is there has to be an appropriate amount of line fill for the system from their other customers, their other shipper customers. That's a condition. You've seen that, haven't you?
My agreement with Medallion says I am not responsible for line.
Yeah, and nor is Medallion, but the other shipper customers are responsible for line fill. Have you seen that condition in the Epic tariff?
I think the reason why we weren't responsible for line pack is because Medallion took that responsibility.
Yeah,
is what I believe
I'll
to be
tell you.
true.
Do you also understand that WTL batches have to be in a minimum of 100,000 barrels?
I understand that per the
Okay.
tariff, and the reason they can't offer that is because they didn't build enough tanks. So they're in default of the contract.
Did ARM ever nominate 100,000 barrels?
ARM did not, but
Did
Glencore Glencore put in a nomination for WTL. And one of the reasons why I struggle with this comment is, which I've talked about with my internal guys too, is every month Epic tells us they cannot take WTL. So we have not been able to build our business appropriately for that WTL service. And how do we continue to put nominations in at our expense and demise every month when they say they can't do it? So that may be a legal technicality, but it is, as a business purpose, I am struggling with this.
Okay, but in any event, my question was, did Glencore, if not ARM, because we know ARM hasn't done anything under this, did Glencore ever nominate 100,000 barrels to flow?
I don't know the exact number, but I know that Glencore nominated WTL per like Mike Glassman's request so that we could get the denial.
So you
There's
could get
30
the-
minutes left.
I'm sorry, ma'am.
You have 30 minutes left.
Thank you. Well, you've said that it won't work, that it's been denied, but look at ARM Exhibit 20. Okay, look at the first paragraph. Epic is expecting to begin a full WTL batching service effective April 1, 2021. That got worked out, correct?
My understanding from Veronica Leland is they did not accept any for April.
Well, did you make a nomination for it?
It's the same thing we were just talking about. They say they can't accept it, so we did not.
Did you
And
even
we terminated the contract on March 29th.
Did you even respond to Mr. Lastman telling him when he told you that they're expecting to begin the full WTL batching service effective April 1? Did you even respond?
Guy may have.
Yeah, but did you?
I don't recall.
Okay, let's look at the second issue regarding loading your full volume of 861,000 barrels. Epic says they'll never be able to load that amount at the existing dock. We've talked about that. When the second dock is complete, they'll have the same issue. C, Epic's position on the million barrels language continues to be that their obligation is up to 1 million barrels. And we've talked about that too. What was the right that you had? Was it to nominate 1 million barrels to a vessel, or was it to nominate a vessel that had a capacity of no more than 1 million barrels because of the channel conditions at Corpus Christi? We talked about that. But you see, D, however, to accommodate your requests as well as others, they have secured space at the Pin Oak terminal and can load and will load your full monthly daily quantity if requested. Do you see that?
I read that, yes.
And indeed, you also had the right to go to MODA, correct?
Not to load a vessel at MODA. We had the right.
What is MODA? What is MODA?
MODA is another vessel loading facility, Your Honor.
How do you spell that for the court?
I think it's MODA.
That's correct.
And you did have the right to go to MODA for no additional expense, right?
We had the right to deliver to MODA for no additional expense, not to load a vessel at MODA.
Right. Let's go to it. Mr. Howell didn't use it, but he marked it this morning as ARM Exhibit 18. You did that, Mr. Dow? Okay. This is an email from Mr. Lastman on January 4 to Mr. Freshwater, Aaron Dunn, and you're copied on it, right?
Yes.
And who is Aaron Dunn?
I believe that is the scheduler for Glencore.
Right. Go to the second page, please. This is December 31, 2020. I want to talk for a minute about this email. You see, December 31, 2020?
Yes.
And that's almost, it's more than 2 months after the October 5 letter, right?
The date is correct.
Now, would you highlight this second paragraph here, please, Mr. Down? Now, Glencore said that it had not declared a carrier default against Medallion under the Transportation Services Agreement, correct?
If that's what that says.
Well, isn't that what it says? It had not declared a carrier default against Medallion, had it? December 31.
Okay.
Objection misstates the email.
So as of December 31,
So why does it misstate the email? Because it says they reserve the right to assert a carrier default. Obviously, that means they haven't asserted the carrier default yet, correct?
Well, we would say that Glencore is reserving its right. Obviously, ARM was not included on this email, and ARM had already asserted the default in October. I don't think he was asked that question, but being asked about what Glencore thought or what Glencore was reserving is a little bit different issue than what ARM had already notified them of.
Mr. Wishoff, you got a copy of this, didn't you?
I may have.
Yeah.
I may have.
And did you?
I don't see my name on there though.
Yeah, it's back on the first page.
Okay.
Your name is right there at the top. Scott
Okay.
Wishoff. You were copying on it, right? That's your email address?
Correct.
All right. Did you call Medallion or did you call Glencore and say, wait a second, no, we have declared a carrier default? Did you ever do that?
That's a legal issue. I don't think I would have ever done that, but I did not know.
So if they haven't declared a carrier default on December 31st, the October 5 letter certainly didn't do it, correct?
It's a legal question.
Well, as night follows day, what is there about that you don't understand?
Well, I mean, I move barrels from one side to another. We're discussing up to 1 million barrels. You know, these are legal things that I'm not versed in.
If Glencore, which stands in the shoes with ARM, had declared a carrier default, Medallion would get 30 days to cure, right?
Per the contract, I believe that is correct. Yes.
And did Glencore or ARM declare a carrier default per the notice, per the requirements of the agreements in January 2021?
I think we're talking about the October letter was our.
No, sir.
notice of
I'm
default.
asking about, we know that as of December 31, Glencore is saying they have it. I'm asking, did you declare one in January?
But it's not my department.
Do you know if Glencore or ARM declared one in February?
I know that we continue to work with you guys after our October note to continue to discuss each month the 1 million barrels, the lack of WTL, and we continue to pay. That's what I know.
Right. And the first attempt, frankly, at declaring a carrier default was this week, isn't it?
That's your opinion.
No, I'm asking you.
I think that, once again, like I said, all I can say is that we sent a letter in October asking for cures, and we continue to pay and we continue to do our business.
And that's the one that Glencore, which is actually operating this, said they had not declared a default.
Objection, misstates the record. You're conflating the December email with about one issue with an October letter about 6 different issues.
Can I ask a question? Can Glencore, are they able to declare, do they have a separate contract that allows them to declare, what is it called? Assert a carrier default against Medallion? Or are they covered by the same thing that ARM is?
It's the same agreement, Your Honor. It was assigned to them.
Assigned to Glencore
Yes, sir.
to obtain a, so.
The rights
who
under
is
the
allowed
contract.
Who is allowed to assert a carrier default against Medallion? Which company? Both or just Glencore?
Both. The assignments are attached as Exhibit 4 that are part of the record. It assigns certain rights to Glencore, and as you see from the emails, Glencore and ARM personnel are copied on most of the correspondence, and they jointly signed the October letter.
Okay.
And,
Go ahead, proceed.
again, Mr.
And there's 20 minutes left.
Thank you. And again, Mr. Wishoff, excuse me, Your Honor. I don't know how to get rid of that. There we go. This Exhibit 18 that we've been looking at, that's not a notice of carrier default, is it?
Oh, and again, that's not I don't deal in carrier defaults. That is not what I do.
I'll pass the witness.
You direct?
Yes. Mr. Wishoff, I'm showing you on my screen the Medallion hearing exhibits, and I want to start with this one, which is the top of the Transportation Services Agreement. Do you see this, sir?
I do.
Who's defined as the carrier under this agreement?
Medallion Pipeline Company, a Texas limited liability company.
You were asked about why there hadn't been line fill provided. Let's look at section 2.05 for who is supposed to provide WTL line fill.
Carrier shall be responsible
And who's
for providing and maintaining. Medallion is the carrier.
Did Medallion ever tell you why they didn't provide the line fill that you needed so that you could provide WTL transportation service?
No, they did not.
All right, I want to show you another exhibit. I'm showing you now exhibit 18. This is an email from Epic in response to a nomination from Glencore regarding a WTL shipment. And Glencore asks, are we good to ship WTL in January? Do you see that?
I do.
And why does Epic say that they can't accommodate WTL service?
It appears that they have not requested line fill from customers.
Okay, and who was it that was supposed to provide the line fill again?
Medallion.
All right, one more exhibit. This is in the terminal agreement. This is the, you mentioned a couple of times that there's an old terminal and then there's supposed to be a new terminal, correct?
Correct.
Why was it important for you guys to be able to access the new terminal at Ingleside?
The new terminal had the superior location, had the superior size. Dredging would occur first, had the superior loading rates. It had nighttime loading, everything that we wanted. And we wanted to avoid the Corpus Christi ship channel.
when did, under this definition of commencement date, commencement of service of these terminals, when did Medallion promise that it was going to have service at the initial terminal?
The initial term, so the way the contracts, if I recall correctly, the way the contracts work, when full service was achieved, which was April of last year, that would be when the new terminal and the Common Stream 1 and Common Stream 2 would be accepted.
Okay. And did that occur?
It's never occurred.
Here, under the definition of commencement date, they say that the new terminal is going to be available June 1, 2020. Did that happen?
It did not.
5 minutes left.
Thank you. Under this agreement, it provides on in section 11.1 notice, and identifies that you have to send a notice to Mr. Lastman, who is the gentleman we've been talking about a lot, and Mr. Simmons. Do you see that?
I do.
Okay. And can you tell me who the October 5, 2020 letter was sent to?
Mike Glassman and Andrew Simmons.
Okay. And each of the items that are listed in this 6-page letter from ARM and Glencore, what does it say about what it wants Medallion to do with respect to each of those alleged deficiencies under the agreement?
We would like them resolved.
All right, one last exhibit. You were asked about the tariff, as if the tariff is perhaps some sort of excuse for not performing. And I want to show you now Exhibit 8, which is the EPIC tariff. I'll show you the cover page first. This is the EPIC Crude Pipeline LP rules and regulations governing the interstate transportation by pipeline of crude petroleum. Do you see that?
I do.
FERC, what does that stand for at the top?
Federal Energy Regulatory Commission.
And what role do they have in pipelines?
They oversee all interstate pipelines. Inter, and it could be intra, but they handle the carrying out of tariffs.
What's identified here in Exhibit B?
Carrier's product specification policy.
And what is this Common Stream 2? Is this the same thing as the WTL we've been talking about?
That is WTI Light or WTL.
Okay, so as of the time you sent the letter in October 2020, this was a product listed in the EPIC tariff. Is that true or false?
I believe that to be true, yes.
Sitting here today, between the time you first got service under the terminal agreement and the transportation agreement, have you ever been able to ship WTL product? And has Medallion ever provided the line fill they're required to provide for WTL service?
No.
Okay. In my last 30 seconds, what are you asking the court to do?
We are terminating this contract. We are asking for our dollars back, and we'd like these issues resolved.
Thank you. Pass the witness.
Mr. Wishoff, you got a copy of Medallion's October 8th letter, right?
I'm sure I did, yes.
Yeah, and do you recall that, why don't we go to that? It's Exhibit 4. Do you recall, Mr. Wishoff, that Medallion specifically said that in closing, we truly value our relationships with AEM and Glencore and appreciate the constructive tone of your letter. Once we have a firm grasp on the situation, we'll work with EPIC to address the concerns raised in your letter. However, currently, we do not view your letter as a notice of dispute under Section 8.4 of the Terminal Services Agreement. If you disagree with our assessment in this regard, please contact me as soon as possible at that phone number. Did you ever respond to Mr. Degater?
I did not. That would not be something that I do. I don't have a legal correspondent.
Did Medallion ever respond to that?
Do you mean Glencore?
I'm sorry, did Glencore or ARM ever respond?
I do not know.
Have you seen any document where they took issue with and said, yes, this is a notice of dispute under section 8.4? You ever seen that?
I don't know if there's one out there or not.
Did you also receive a copy of Epic's response that was attached to Medallion's November 16, 2020 letter?
Can I ask a quick, well, wait, can I ask a quick question here?
Yes, sir.
So the October letter that you just, okay, sorry, the one you were just showing on the screen refers to, I think, 8.04 and not
8.4. Yes, sir.
8.4. It's not citing to 6.04.
This provision says, yeah, this provision, Your Honor, says that if there is a dispute, you need to notify the other side, and they need to have a meeting within, they need to identify a senior representative within 3 days so they can sit down and try to resolve it.
Mr. Patterson, I thought that there was, or maybe I misunderstood it. Was there ever any communication by Medallion to ARM that they thought that the October letter did not comply with 6.04 of the transportation agreement? Or is this the one that we looked at the other day?
Well, what we said to them was, we do not regard this as a notice of a breach, notice of a dispute.
And where is that? Is that in, I thought you provided something in writing before.
It's at the bottom of page 2 of Defendant's Exhibit 4. Let's go back.
I see that.
Your Honor, the default and termination provisions of this contract are in section 13 and section 13 of one contract and section 6 of another contract. Both of those sections, 6.04 and 13.2, allow for termination of the contract after there's a written notice. Section 8.4 is a totally different provision that says that the parties can go negotiate before or after termination.
Is this what you showed me the other day, Mr. Patterson?
I'm sure I did, Your Honor.
Remember you showed me something, you said in response, we got crickets. Is this what you showed me the other day, or is it something else?
Well, I think well, it was this, plus the Epic letter that we sent to them, Epic's response to all of their complaints. So if I can parse this out, section 8.4 requires that in the event of a controversy, claim, difference, or dispute between the parties arising out of or related to this agreement, or the performance, breach, validity, interpretation, application, or termination thereof, then within 3 days following the date of delivery of a written request by a party, each party shall appoint as its representative a senior officer with full authority to resolve it.
Keep reading.
Who shall meet and attempt to resolve the dispute informally as soon as possible.
One more
That's
sentence.
why we said to them that we did not regard their October 5 letter as a notice of dispute. And if they disagreed, to tell us.
Your Honor, he needs to read one more sentence.
The other thing that we sent to them, Your Honor,
Is it, read one more sentence. I'm not sure why, but he wants you to read one more sentence.
if such representatives are unable to resolve the dispute within 30 days of the date of the foregoing notice, then either party may elect to proceed with any legal action or proceeding available under applicable law.
It doesn't say we can't terminate. It says that we have to meet before we file suit. This is a completely inapplicable provision.
Who's talking?
I'm sorry, this is Gabe Newley, the internal counsel at ARM. I apologize.
So we never got that, Your Honor. We asked them in an abundance of caution, hey, if this is a notice of breach, tell us. And they didn't respond.
Okay, I think I may have misunderstood this the other day, that I thought that you said, and maybe I misunderstood it, is that under that your side said to them, hey, under 6.04 of the transportation agreement, we don't consider this a notice of default. Please let us know if you do.
Yeah.
And it was actually under an entirely different agreement that you're talking about now, right?
Well, it's under the terminal services agreement, and it says if there's any dispute, they shall give us this notice. Because
that doesn't cover the whole right, the whole right to cure.
Yes, Your Honor, it's a different section of the contract.
Right.
The different section of a different contract or the same contract?
Different section of a different contract, and we have the right to terminate under that. The other section, 6.04, gives us the right to send the notice, and then if there's not a cure, we terminate. This is under a different contract, and it allows for this meeting to occur after termination. It says, in the event of any controversy arising out of this agreement, the performance, application, or termination thereof, then 3 days following the delivery of the written request, then the meeting happens. That already happened. So on March 29th, Your Honor, we sent the notice of termination. We immediately requested the meeting under 8.4, and the parties conducted a meeting regarding the termination under section 8.4. This meeting that he's talking about, the thing that he tried to raise in the TRO hearing to block the TRO, is a totally different section that doesn't prevent termination of the contract. It's a different section of a different contract.
It doesn't prevent termination, but what it requires is in the event of a controversy, we'll just start there. In the event of a controversy, they shall notify us and require this meeting of the parties. And they didn't do that. And we specifically pointed it out to them. Is that what you're talking? If that's what you're talking about, tell us. Because we don't read your letter of October 5 to put us on notice of a controversy, claim, difference, or dispute between the parties arising out of or related to this agreement for the performance breach, validity, interpretation.
But this meeting that's supposed to occur, is that supposed to occur after a notice of default or after a termination?
It occurs simultaneously, Your Honor.
Your Honor, may I be heard? I apologize. So the letter he's talking about on October 8th says, let us know if you disagree that we don't take this as a notice of dispute. We don't disagree. We didn't then and we don't now, because that provision only applies if we plan on filing suit. At that time, we were not planning on filing suit. We were planning on terminating the agreement. All that says is, before you go out and file suit, there's an exception with the injunctive relief. But if you otherwise plan to file suit or a legal proceeding, then we have to have a meeting.
Your Honor, there's nothing in that provision that supports what he just told you. There's nothing in that provision that supports what he just told you.
Richard, will you read the remaining paragraph?
Just show the paragraph so I can see it. I feel like it's not hard. No, not 6.04. We're talking about 8.4 of the other agreement.
8.4.
But I thought it was a different agreement, not this one. This is attached to the other agreement?
This is part of it. This is section 8.4 of the terminal services agreement.
There are two separate agreements, 6.04 and section 13 of the terminal agreement provide for a default notice followed 30 days later by a termination. This is a different section of the terminal agreement. It only appears in that one contract, and it's under Article 8, governing law. And as Mr. Newley was suggesting, this relates to when there's going to be litigation. And here's what the passage says, and you can obviously read it for yourself. But this meeting can occur before or after termination. And that meeting already did occur on March 29th, after termination, before the TRO hearing.
Respectfully, Your Honor.
Sir, it says if such representatives are unable to resolve the dispute within the 30 days of the date of the foregoing notice, then either party may elect to proceed with any legal proceeding available under applicable law, subject to section 8.4. We were not at that time going to have any legal proceedings or pursue any legal proceedings. We were going to terminate. It says, if you have that, once you have that meeting, if you don't resolve the issue, at that point, you can file suit. We were never going to file suit.
Okay, I get it. All right, let's,
Yeah. The
you have
other,
anything else?
one more question for Mr. Wishaw. You received a copy of the November 16 letter from Medallion, correct?
I don't recall.
Well,
I assume I was copied on it.
let's put it up on the screen. All right. Let's go to the second page, please. Okay, let's look right there. CC Mr. Scott Wishaw. You see that?
I do.
All right, now go to the next page, please. This is where Medallion is again requesting information, and it is forwarding to you a copy of Epic's response to the allegations that you made in the October 5 letter. Now, do you recall that?
I recall this. Yes, Glencore. This was mainly between Glencore and Medallion. I was copied. Yes.
Did ARM ever respond to the Epic letter or to the November 16 letter from Medallion and say, we disagree with your interpretation of the contract?
I think we did that every month by saying, can you take 1 million barrels? No problem. Can you take WTL? No problem. Have you built a new terminal? No problem. We do that every month. As I said, starting in October, we made it formal, and we still continue to work with you. We still continue to pay bills. And so yes, every month we make that an issue.
I'm looking for something, sir, that would satisfy the notice provisions in the contract. Did you ever provide a notice of that what Epic was saying was just wrong?
I don't provide legal notices or the like. No.
Nothing further, Your Honor.
Nothing else, Your Honor.
Okay. Mr. Patterson, are you going to call any witnesses?
No, sir.
Okay. Let's hear briefly, how much time does the plaintiff have left?
About a minute.
Okay. Go ahead, Mr. House, your final argument.
Yes, Your Honor. Thank you very much for your time, and thank you also for giving us this opportunity this afternoon. We believe that we've satisfied the requirements for a temporary injunction. We have a cause of action. We believe we have a probable right to recover on our declaratory judgment claim that there was a breach of the contracts and that we are entitled to terminate them. Mr. Christopher identified the imminent risk of irreparable harm and why there's no adequate remedy at law. We believe you should grant a temporary injunction to prevent Medallion from drawing on the LCs. Those LCs would remain in place while this litigation is pending, but it would prevent them from taking the money and having, in addition to the $14 million already in its pocket, it would keep it from getting the additional $19 million that's pending with the bank. We believe that you should withdraw your interim factual finding about the October letter and grant a temporary injunction that allows those letters to remain in place until trial on the merits.
Okay. Response? How much time does the defendant have left?
13 minutes.
Okay, go ahead.
Your Honor, for the court to enter the temporary injunction that ARM's asking for, the standards, they have to show they have a valid cause of action. That is that they properly terminated the 2 agreements this week, and Medallion's draw on the LCs would be a breach of contract. They need to show that they have a probable right to relief, and they need to show imminent and irreparable harm. For purposes of today's hearing, before we ever get to whether Medallion breached the agreement, the preliminary issue has to be whether ARM followed the steps that it needed to in order to authorize it to declare that the two agreements are terminated. We maintain that they didn't, and certainly not as of this week when we received their notice of default. ARM pins their entire injunction argument on whether its October 5 letter to Medallion satisfied the notice requirements of the two agreements so that ARM could declare that the agreements were terminated as of March 29. It did not. The notion that they put us on notice of default in October is wrong. Almost 6 months after sending the letter on operational issues, we think they're trying to transform that letter into a notice that simply doesn't exist. To put Medallion on notice of a default under the Terminal Services Agreement, we go to page 145, Kevin. It's Defendant's Exhibit 19 at section 13.1. It provides that a party shall be in default if it is in breach of any of its material obligations under this agreement, and such failure continues for 30 days after the defaulting party's receipt of written notice from the non-defaulting party as to the breach, provided that if the defaulting party cannot reasonably cure the breach within 30 days, and it diligently pursues a cure, then it gets 60 days. We think that Defendant's Exhibit 1, the October 5 letter, doesn't say a word that it's a notice of default under section 13.1. It doesn't say anything about Medallion needing to cure within 30 days. It doesn't make a demand for the meeting with executives under section 8.4 that we just looked at. None of it. To put Medallion, that's the Terminal Services Agreement. To put Medallion on notice of default under the Transportation Services Agreement, we go to page 103 of Defendant's Exhibit 18, section 6.03. Page 103. There we go. It defines a carrier default as the occurrence and continuation of a material breach or default by carrier of any of its obligations under this agreement. Section 6.04a specifies that upon the occurrence of a carrier default, shipper may provide written notice to carrier describing the carrier default in reasonable detail and requiring carrier to cure the carrier default. 6.04b then provides that if the carrier default has not been cured within 30 days after receipt by carrier of a carrier default notice, or if it isn't and it's not reasonably capable of being cured within 30 days, but the carrier is expeditiously commenced to cure following its receipt of the default notice and diligently proceeds, then the carrier may ask for additional time. The October 5 letter doesn't say a word that it's a notice of default under 6.03. Doesn't say anything about requiring Medallion to cure within 30 days. It doesn't say that if Medallion doesn't cure within 30 days, Glencore will terminate. I'd ask the court to compare and contrast that October 5 letter with the letter that ARM sent to us on Wednesday night of this week. That's Exhibit 22. This was after the mediation. I got it about 8 o'clock on Wednesday night. Go to page 2. There it says, starting with the last paragraph, ARM says that if its October 5 notice was not sufficient, it is now giving notice of a carrier default. It cites the default provisions in Article 13 of the Terminal Services Agreement and in Article 6 of the Transportation Services Agreement. It insists that Medallion cure within 30 days it references the section 8.4 notice of dispute in the terminal services agreement. It's pretty clear. It's pretty clear in their letter from this Wednesday, no guessing required, but it only underscores how the October 5 letter didn't do any of these things. And a party shouldn't have to guess about what a letter really means, especially a letter that supposedly declares a default. Even if,
Remind me, does the October letter ever use the term, what is it called, notice of event of default at all in it?
no, sir.
Okay.
Even if there had been a breach of the underlying operational duties, which we vigorously dispute, and I think you got a flavor of that today, the October 5 letter that ARM and Glencore sent to Medallion did not qualify as a notice of dispute under either agreement. The conduct of the parties in the months that followed October 5 certainly do not support the notion that ARM or Glencore were threatening default. We saw the agreement, or we saw the internal email from Glencore saying, we reserve our right to declare default. They hadn't declared it. Were there issues that Glencore was raising? Yes. Were they getting worked out? Yes. Whether it had to do with Epic, whether it had to do with loading vessels, whether it had to do with shipping WTL, those issues were getting worked out. ARM is not entitled to invoke the termination rights it claims, but there's more. You know, ARM wants equity, but it didn't give equity. In Defendant's Exhibit 4, which is our October 8 letter, at pages 31 to 32, when we just looked at this, Medallion responded to their October 5 letter, asking for documentation that supported the claims. ARM never provided it. ARM never provided that. In DX4, there, you know, a full paragraph, bottom of that first page, and much of the second page, asking for information to substantiate the claim. You can't just assert or allege a breach and make it a breach. In DX4, page 32, we also expressly said we didn't view the letter as a notice of dispute under section 8.4, but please tell Medallion if they disagreed. And they didn't, not until this week. And there's more. Medallion sent that October 5 letter, as we've just seen, to Epic, and Epic evaluated the contentions and responded. In DX5, at page 34, on November 16, Medallion forwarded that detailed response to ARM and Glencore. They never responded that they disagreed with the explanation of what was going on. They never provided the information which Medallion again requests. ARM did not give the required notice on October 5. It clearly knows how to do it. It did it this week, but it didn't do it on October 5 in that instrument. And because their application for a temporary injunction hinges on that October 5 letter, it is not entitled to terminate anything. It has no right to insist that Medallion not draw on the LCs based on ARM's default under the Transportation Services Agreement for failure to post additional credit support. Interestingly, Your Honor, they've never said a word here about our right to draw on those LCs if they haven't terminated. They've not said a word about that. So if they did not have the right to terminate this week, they have not put at issue here in this, at least in this hearing, Medallion's right to draw on those letters of credit to satisfy the credit assurance that ARM agreed would be provided for the term of the contract, not just for a day or a month, but for the term of the contract. Respectfully, Your Honor, We've heard their allegations about irreparable injury. There's a prospect of what they call a death spiral. It's a great phrase. They don't know. They can't give you proof that there is going to be imminent and irreparable injury. They can just speculate on that. So we don't think that they're entitled to a temporary injunction. They don't have a right to terminate at this time. Medallion is entitled to draw on the LCs. They have no irreparable injury. Our application for a temporary injunction should be denied. Their application for a temporary injunction should be denied. And really, ARMS shouldn't be allowed to use the court to walk the terms of contracts that it made with Medallion. Thank you, Your Honor.
Your Honor, may I be heard for 15 seconds?
Sure.
All right. First, Mr. Patterson just said that they sent a letter saying that they knew there were claims and they asked for documents supporting those claims. So Medallion knew there were claims. Second, you saw the emails from Mike Lassman and the other people at Medallion after we sent the October letter. They knew that there was a failure to perform. And on Tuesday, he told you there were crickets. But today, we've shown you evidence that there were repeated emails between the parties to try to seek a cure for these breaches. What Medallion said was they will never be able to perform. They've never been able to perform WTL because they won't provide the line pack to go in the line. And they've never been able to perform the terminal agreement because they won't build the terminal to provide the 1 million barrel ship. I mean, talk about someone wanting to walk an agreement. And finally, Your Honor, in the letter, it doesn't say this is an event of default, but what it says is, quote,
This is way beyond 15 seconds. I just want to point out. So, all right. So I've heard the arguments here. I appreciate them. This is a tough call, tougher than I thought. What my concern is I guess the one legal issue I don't really know the answer to is what is required to put someone on notice that they have the right to cure, because obviously the most recent letter, I think, would be, so if that language had been included in the initial letter, none of this would be an issue. I mean, it would have been clear to Medallion, look, we put you on notice of default, but the letter doesn't say notice of default. The letter doesn't say you have a right to cure. And so, I've read that you have to put them on I don't remember the exact language, but essentially reasonable notice. Has anyone looked at the law on what is required in terms of notice of default and what is required in terms of the right to cure? Has there been any case law on that? Because that to me is where I'm really struggling. Obviously, the most recent letter would have been best practices, would have been made this all very clear and quick, and we wouldn't be in this situation. The original letter obviously wasn't best practices, but is it sufficient under the agreement?
I think
that's a close call.
I think the answer is that it's defined by the contract, Your Honor. So the notice of default has to be a notice, and it has to be in writing. It has to identify what the default is. And what notice is defined as in the contract is, quote, any notice, statement, claim, or other communication. So it's very broad in terms of what we must provide them. So a letter is a written statement, and it identifies the alleged quote, material violations of the terminal services agreement, which is exactly what that October letter says. And it says there are several ways Medallion can resolve these issues. So it may not have been, but it's
a good argument, I guess. So I'm going to give you guys a couple of options here. One is I can just rule now based on shooting a little bit in the dark because I don't know when his research is this. And I'll be honest, I must have misunderstood Mr. Patterson. I thought that the subsequent letter said, hey, we don't think this is a notice of default under 6.04. I didn't realize until today it didn't say that. It was under some other agreement about, and so that would have made this clearer too if the subsequent letter had said, we don't consider this a notice of default, and then there hadn't been a response. uh, I can either just rule now, and I do think it's a very close call, or I can give you guys the weekend to brief this issue of what constitutes, someone putting someone on notice of the right to cure. Is there any case law out there about that? What is y'all's preference?
I probably need to defer to my client, Mr. Degater.
Yeah, I guess, can I address the court? Is this something I can do currently?
Sure. I mean, the other guy did, so I guess you can too.
Yeah, just as helpful in the discussion as the writer of the October 8th letter, our interpretation of section 8.4 of the terminal services agreement, which in fact, if they're right, they're alleging a breach of the terminal services agreement. But at the end of the day, our interpretation of section 8.4 is that certainly for it to be a default under 6.4 or 14.13, it has.
Well, let me ask you this. I guess what would have been helpful, and this is another thing that causes me, pause, is you were never called as a witness. Did you take the October letter as a notice of default under 6.04, or did you not? I mean,
I would say I absolutely did not. And for all of the reasons that Mr. Patterson outlined, I'm happy to I'll be sworn in and testify currently. I did not. For all of the reasons they testified, I've been at this for 20 something years. I am a serious lawyer working for a serious company. If we were notifying ARM of an event of default, we would do exactly as we did, which is specify in very specific terms why we believe we are alleging a breach of default, give them the opportunity to respond to that, which in fact we have, and then pursue our remedies, which we are trying to do now, but are currently being muted in. All of the reasons cited by the CFO of ARM for the fact that we have this credit support posted are exactly why the judge should not put in favor of the plaintiffs today. That this is exactly the situation that these credit support mechanisms are intended to protect us from. But at the end of the day, in answer to your question, absolutely not. I would expect any competent event of default notice to say it is such at the very front. And I mean that
I don't disagree with you. This would have been a lot simpler if that's what had happened.
And I guess, Your Honor, the other point I would make is that we view the standard for 8.4 and the requirement that the parties get together and discuss any dispute, any issue. I mean, it's very small. That is not optional. If you read the language, it is absolutely necessary if you believe that there is a dispute under the contract. And so we believe that as mandatory.
I give you some time. So, Mr. Patterson, you can talk to your client. I don't mind taking a break if you guys want to chat about this. In fact, I need to take a break pretty soon. I've been going at this for a while. Do you guys?
5 minutes, Your Honor.
Yeah. Do you guys need to go do I need to put you into breakout rooms, or can you guys call each other?
We can call.
Okay. Both sides, why don't you chat about this option? So you understand the two options. One, I rule today. Second, I give you a chance to research over the weekend. That means the TRO would be extended over the weekend. I don't want there to, it would have to be extended over the weekend. And then you guys get me briefing by Monday morning. I hate to do that to you, Mr. Downey, because I know you'll be doing all the research as the young lawyer here. And hey, good job handling all the exhibits today. Good job, is it Mr. Downey? Is that right?
Down.
Mr. Downs.
Downs, sorry, Mr. Downs. Good job today.
Thank you.
But I hate to ruin your weekend, but it would be helpful to know the answer to this if that's what they decide to do. If not, I'll just take a shot in the dark and do my best. So you guys take the chance to research this or chat amongst yourself, and I'll be back in about 5 minutes.
Thank you, Your Honor.
Okay, everyone. All right, what's the decision by the plaintiff?
Your Honor, we would like the opportunity to brief the issue for you on Monday. We'd also ask that you limit the brief to something like a 2-page letter.
Yeah, that's a good idea. I like the 2-page letter, and only on this one topic. I don't want a recap of everything else.
Yes, Your Honor. And the only other thing I would say is that the defendant chose not to call any witnesses, and Mr. DeGuyter's post close of evidence testimony.
I'm not considering it as testimony in this case.
Thank you.
Mr. Patterson?
Your Honor, we prefer that the court rule today.
Okay, well. As I said, it's a tough call. I can't, I guess I'm just trying to think of my legal options here. Under the law, I can extend it on my own motion one time. I have not extended this TRO before, correct?
That's correct.
Was hoping to do it the easy way. This is kind of the hard way. All right, I'm going to extend the TRO to Monday. I'm going to give each side the opportunity to provide up to a 3-page brief on the issue of what we talked about, the right to cure and what constitutes a notice of default. And you can just, if you're just going to cite to the contract, you can, but I'd really like to see case law on this if possible. And if you want to provide, in addition to the 3 pages, if there is a case citation of a particular important case, if you want to just attach, not the entire case, but just the relevant portions of the case, that would be helpful too. Email that to Rhonda, my court coordinator, the briefs by, and e-file them by Monday at 5. And Mr. Howell, get me an order forthwith extending this TRO to email that to Rhonda and e-file it as well. And this TRO, does the TRO expire at 5 or does it expire at, did I say?
It expires at 5 p.m.
Well, I would get cracking because you'll need to get that to me right away. I would have I would try to call Rhonda once I get it. I'll wait here till 5. And I'll make sure I get it signed by 5, but you got to get it to me right away.
Yes, sir.
All right, guys.
Thank you, Your Honor.
Thank you. And if you could each submit to me, if you already submitted an order denying and granting this TI.
We provided an order granting the TI, Your Honor. If for some reason you were to rule the other way, when we don't think you should, perhaps you should consider ordering them to repay the deposits and the LC amount within 3 days after the re-termination. But that may be premature.
Well, it's grossly premature because they only get that if there's been a final hearing on the merits, final judgment on the merits.
No, it's not what the contract says. It says we get the money back immediately after termination.
Mr. Howell, I'm just telling you, you have very little time to get this order together, so I'm not going to go beyond it. It'd be just a strict denial or grant is what I'm going to do. So,
Understood.
All right, get that into me by 5.
Yes, sir.
Thank you, guys.
Thank you, Your Honor.